Welcome back to Oath&Ink Academy. Today's topic is one that comes up more than almost any other question I receive from notaries at every level, and it trips up beginners and experienced notaries alike. What do you do when a signer hands you a document and there is absolutely no notary section on it? No acknowledgement block, no jurat, no signature line for you, just a blank stare at the bottom of the page. Do you send them away? Do you refuse? Do you write something yourself? The answer involves a very specific, legally recognized process, and by the end of this presentation, you will know exactly what to do, what to say, and how to complete that notarization correctly and professionally every single time. Let's get into it. Before we get into the solution, let's understand the problem, because knowing why a document is missing its notary section helps you respond confidently and professionally. First, many documents circulating today were created without legal counsel. Someone downloaded a template, drafted their own agreement, or printed a form from an unofficial website, and the notary block was simply never included. It happens constantly. Next, foreign and out-of-state documents are another common source. A document originating in another country or another state may follow completely different formatting standards, leaving the notarization format open for the receiving notary to determine. And third, businesses and agencies often create internal documents, employment agreements, internal affidavits, organizational forms that require notarization but weren't professionally formatted to include one. Keep in mind the governing principle here. The absence of a pre-printed notary section does not mean you have to turn the signer away. It means you need to know the correct solution, and that solution is called a loose notarial certificate. So what exactly is a loose notarial certificate? First, let's define it clearly. A loose certificate is a separate page that contains all the required language of a notarial act, an acknowledgment or a jurat, that gets physically attached to the original document. It is not some improvised workaround. It is a professionally recognized, legally accepted tool used by notaries every day across the country. Next, there are 4 things you need to know about how it works. 1. It's legally valid in all 50 states. You are not doing anything irregular or unusual by using one. 2. It must use your state's required wording. You cannot make up the language. Tennessee has specific legally mandated certificate language for both acknowledgments and jurats, and we'll look at those in a moment. 3. It must be physically attached to the document before it leaves your hands. Staple it securely. Never leave a loose certificate unattached. Why? Because an unattached certificate can be fraudulently paired with a different document later. 4. The certificate must identify the document it's attached to. It's worth noting that the identification language is what creates the legal link between your certificate and the specific document you notarized. Step 1. And this is the most important decision in the entire process. You must determine which type of notarial act the document requires. Why does this matter so much? Because using the wrong certificate type is a notarial error, and it can invalidate the document or create legal liability for you. First, let's talk about an acknowledgment. This is used when the signer is simply confirming that they signed the document voluntarily. Here's the key. With an acknowledgment, the signer may have already signed the document before they appear before you. You're not witnessing the signature, you're verifying their identity and confirming they acknowledge their signature. Real estate deeds, powers of attorney, and most contracts use acknowledgments. Next, the jurat. This is completely different. A jurat requires the signer to swear or affirm under oath that the contents of the document are true, and with a jurat, the signer must sign in your presence, always. You must also verbally administer an oath or affirmation before they sign. Affidavits and sworn statements use jurats. Bear in mind a quick test. Ask yourself whether the document contains sworn statements of fact. If yes, it likely needs a jurat. If the signer is simply acknowledging their own signature, it's an acknowledgment. When in doubt, tell the signer to confirm with whoever is requesting the document. Step 2. And this entire step happens before you write a single word on a loose certificate. First, verify the signer's government-issued photo ID. This comes first, always. Before you look at the document, before you prepare any paperwork, confirm the identity of the person in front of you. The name on their ID is the name that will appear in your certificate. No ID, no notarization. Next, inspect the document itself. Is it complete? Every field must be filled, No blank lines, no partial entries. If the document has blanks beyond the missing notary section, stop right there. A blank document is an incomplete document, and you do not notarize incomplete documents. Then assess the signer. Have a brief conversation. Are they lucid? Do they understand what they're signing? Are they signing willingly, without pressure? If anything feels off, they seem confused, frightened, or coerced, trust that instinct and decline. Keep in mind that step 4 of this pre-check is one many notaries overlook. Write down the document's title, the date on the document, and its page count before you prepare the loose certificate. You'll need these details to properly identify the document in your certificate language, which is what legally ties your certificate to that specific document. Step 3. Preparing the actual loose certificate. And here is a rule I cannot stress enough. You must use your state's legally approved certificate language. You cannot simply write your own version from memory, and you absolutely cannot improvise wording. Many states have specific statutory language that must appear in your notarial certificate, and using incorrect or incomplete language can make the notarization legally defective. First, where do you get the approved language? 4 places. Your state's official notary handbook from the Secretary of State. This is your primary resource. The National Notary Association, which offers state-specific certificate templates and physical pads. Pre-printed certificate pads available from notary supply vendors. These are pre-formatted, state-approved, and incredibly convenient. Bookmark it today. Next, every loose certificate you prepare, regardless of document type, must contain 9 elements: the state and county, the date of your notarial act, the signer's full legal name, the ID type used, the document identification, your signature in ink, your printed name, your commission expiration, and your notary seal. One thing to remember is that all 9 of these elements are required. A missing element is a defective certificate. Here is a complete, fully tagged loose acknowledgment certificate, so you can see exactly what the finished product looks like. Let's walk through the key fields. First, fields 1 and 2. State and county reflect your commission jurisdiction. If you are a Tennessee notary working in Montgomery County, that is what goes here, regardless of where the signer lives or where the document originated. Next, pay close attention to fields 3 and 4, the document title and page count. This is the identification language that legally ties your loose certificate to the specific document. For example, you might write, "This certificate is attached to the following document, General Affidavit, consisting of 2 pages. Why is this so important? Because without that identifying language, someone could theoretically remove your certificate and attach it to a completely different document. Fields 3 and 4 prevent that. Field 5 is the date of your notarial act, today's date. Field 6 is the signer's full legal name, exactly as it appears on their ID. Field 7 is the ID type and number. Keep in mind that fields 8 through 11 are exclusively yours to complete. Your ink signature, your printed name as commissioned, your commission expiration date, and your official notary seal. All 4 must be present, legible, and accurate. Any missing element creates a defective certificate. Now here's the loose jurat certificate, and notice that while the structure looks similar to the acknowledgment, there are critical differences in both the language and your procedure. First, look at the certificate language itself. Instead of "acknowledge executing this document voluntarily," a jurat reads "subscribed and sworn to before me." That phrase is the legal fingerprint of a jurat. It must appear exactly as prescribed by your state statute. Do not paraphrase it. Do not improvise it. Use the approved language from your state notary handbook. Next, and this cannot be overstated, before the signer picks up the pen, you must verbally administer the oath or affirmation. You say something like, "Do you swear or affirm that the statements in this document are true to the best of your knowledge?" They respond affirmatively. Then they sign. The oath comes first, always. And unlike an acknowledgment, the signer cannot pre-sign a document that requires a jurat. The signing must happen in your presence after the oath. Just remember that a jurat carries perjury implications. The signer is swearing to the truth of the content under penalty of law. Make sure they understand that before they sign. Your loose certificate documents that this oath was properly administered. Step 4. Completing the notarial act and properly attaching the loose certificate to the document. And here I want you to pay careful attention to the sequence, because for acknowledgments and jurats, the order of operations is slightly different. First, for an acknowledgment, verify the ID, confirm the document is complete, confirm the signer acknowledges their signature voluntarily. Then complete your certificate, sign and seal it, and staple it to the document. For an acknowledgment, the signer may have already signed the document before coming to you. That is acceptable. Next, for a jurat, and this is where the sequence changes significantly. The document must not be pre-signed. The signer must come to you with the document unsigned. You verify their ID, confirm the document is complete, administer the oath verbally, witness the signer's signature, then complete your certificate. Sign and seal it, and attach it. The gold highlighted steps in each column are the ones that belong exclusively to you as the notary. Those steps are your notarial acts. Most importantly, the attachment rule at the bottom of this slide. Staple the certificate to the front of the document securely before it leaves your hands. Not a paperclip, not folded inside, stapled to the front. A loose certificate that becomes physically separated from its document loses its legal connection to that document. Staple it every time. Step 5. And the one step that protects you long after the signer has left your presence. Record every notarization in your notary journal, no exceptions, not even if it was a quick job, not even if the signer is in a hurry. Every single notarization. First, look at the sample journal entry on this slide. Notice what it includes: the date and time of the act, the document type, and specifically noting that a loose certificate was attached, the document date, the page count, the signer's full name, their ID type and number, with expiration, their address, your fee, and their signature in your journal. All of these entries create a comprehensive legal record. Next, why does this matter so much for loose certificate notarizations? Because when you perform a notarization on a document that had no pre-printed notary section, the paper trail is especially important. The document itself has no built-in trace of your involvement beyond the attached certificate. Your journal entry is the independent record that confirms the act occurred, who was present, what ID they showed, and when it happened. Keep in mind, if that loose certificate is ever challenged, disputed, or part of litigation, your journal entry is what you point to. It's your receipt. It's your evidence. It is the most important habit a professional notary can develop. Now let's talk about what you absolutely cannot do, because knowing your limits is just as important as knowing your authority. First, you cannot choose the notarial act for the signer. If someone hands you a document with no notary section and no instruction on whether to use an acknowledgment or a jurat, you cannot make that decision for them. Tell them to contact whoever is requesting the document and ask for clarification. Choosing for them crosses into legal advice territory, which is outside your authority as a notary. Second, you cannot write your own certificate language. I know this seems obvious, but notaries sometimes improvise when they can't find a template. Don't. Use the statutory language approved by your state. Improvised wording creates a defective certificate that may be rejected or challenged. Third, and this is fundamental to everything we've covered, the signer must be present. A loose certificate is not a workaround for remote sign-in. The signer appears before you, you verify their identity, and you perform the act in real time. No exceptions. Fourth, never leave the certificate unattached. If that certificate and document become separated, the legal connection between them is gone. Staple before delivery. Fifth, remember that your seal certifies the signer's identity and the performance of the act. It does not certify that anything in the document is true, accurate, or legal. That distinction protects you from being held responsible for document content. Here is your complete printable action checklist, all 10 steps in order for every time a document comes to you with no notary section. Print this slide, keep it in your notary bag, run through it every single time. Steps 1 and 2 happen before you do anything else. Verify the ID, inspect the document for completeness. Step 3 is your decision point, acknowledgment or jurat. Make this determination carefully and confirm with the signer if you're unsure. Steps 4 and 5 are about preparing the certificate. Get state-approved language, and fill in every required field. Step 6 applies only to jurats. Administer the verbal oath before anything else. This is the step that trips up notaries who skip it. Don't. Steps 7 and 8. Complete the act. Sign and seal your certificate. Step 9. Staple it to the front of the document before it goes anywhere. And Step 10. Open your journal. Record every required field and have the signer sign it before they leave. Take into consideration that these 10 steps work for every loose certificate situation you will ever encounter. Simple affidavits, contracts, business agreements, foreign documents, you name it. The document type changes. The process does not. Master this checklist and you will never be caught off guard when a document without a notary section lands on your desk. And that is a wrap on today's lesson at Oath&Ink Academy. Let me give you the 3 sentences that summarize everything you learned today. When a document has no notary section, you don't turn the signer away. You attach a loose notarial certificate with state-approved language. You determine the correct act, acknowledgment, or jurat based on the document's purpose. And you verify the identity, complete all 9 fields, staple the certificate to the front, and record the notarization in your journal. That is the complete legally sound process. You came in with a question that has stumped notaries at every experience level, and you are leaving with a 5-step framework, 2 tagged sample certificates, and a 10-step checklist you can use starting today. If this video helped you, please like it and share it with a fellow notary. This is exactly the kind of knowledge that protects the profession and protects the public. Subscribe to Oath&Ink Academy for more professional-grade education delivered just like this. Clear, complete, and ready for real work. I'll see you in the next one.